Picture this. You're pulled over. Routine traffic stop. The officer walks up to your window, asks for your license and registration. Totally normal. But then, before you even process what's happening, he reaches through the window and takes your phone right out of your cup holder. No warning. No explanation. No warrant. He just starts scrolling. Do you have the right to stop him? Do you say something? Do you stay silent? And here's the question that actually matters. Does it even matter what you say? Legally speaking, most people in that moment would freeze. Not because they're guilty of anything, because they genuinely don't know what the law actually says about this. And that gap between what you assume your rights are and what they actually are, that gap is exactly where things go wrong. So let's close that gap right now. Because what the Supreme Court decided about your phone and police searches is one of the most important legal developments of the last decade. And most people have never heard the full story. Quick note before we go any further. I'm not a lawyer, and nothing in this video is legal advice. This is educational content only. Laws can vary by state and situation, so for anything specific to your circumstances, please talk to a qualified attorney. Now let's get into it. For most of American legal history, the rules around searches and seizures operated on a pretty simple framework. The Fourth Amendment to the Constitution says the government cannot conduct unreasonable searches and seizures. And for physical things, your car, your pockets, your bag, courts developed something called the search incident to arrest doctrine. The idea was if you're lawfully arrested, the police can search you and the area immediately, around you without needing a warrant. The justification was safety, making sure you're not hiding a weapon and evidence. Preservation, making sure you don't destroy something relevant right in front of them. For decades, that doctrine applied to pretty much everything on your person at the time of arrest. Your wallet, your notebook, your pager. If a cop arrested you and found a folded piece of paper in your pocket with a phone number on it, they could read it. No warrant needed. Courts consistently upheld that logic, and it made sense in a world where the stuff people carried was pretty limited in scope. Then smartphones happened, and everything got complicated in a way that lawmakers and courts genuinely weren't ready for. Think about what your phone actually is for a second. It's not a piece of paper with a phone number. It's not a wallet with some cash and a few cards. Your phone contains your entire life. Text messages going back years. Every photo you've ever taken. Your location history, every place you've been. Time-stamped. Your emails, your medical apps, your bank account, your private notes, your browser history, your search history. The people you've talked to, what you talked about, when you talked. Your phone knows more about you than your closest friend does. Probably more than you consciously remember yourself. So the question became, can that doctrine designed for wallets and pocket knives really be applied to a device that is essentially a window into a person's entire existence? In 2014, the Supreme Court answered that question, and the answer was one of the most unanimously clear rulings the court had, delivered in years. The case was Riley v. California, and what the court said changed the legal landscape permanently. Here's what happened. David Riley was stopped for a traffic violation. During the arrest, an officer took his smartphone and went through it, found evidence connecting Riley to a gang shooting. That evidence was used to convict him. Riley argued the search was unconstitutional. The case went all the way to the Supreme Court, and the court, all 9 justices, agreed with Riley. Chief Justice John Roberts wrote the opinion, and he said something that cut straight to the heart of it. He acknowledged that, yes, the old search incident to arrest doctrine made sense for physical items. But a smartphone, he wrote, is not just another technological convenience. The data on a phone is so deeply personal, so comprehensively revealing, that treating it like a physical object you're allowed to rifle through incident to arrest would be a massive and unjustified invasion of privacy. He even used a line that's worth remembering. He said that a person arrested today carries in their pocket the privacies of life. And the Fourth Amendment was designed to protect exactly those privacies. The ruling was clear. Police need a warrant to search your phone, full stop. Now, and this is the part most people don't know, that ruling, as powerful as it is, has real exceptions. And those exceptions are where the danger actually lives for most people. The first exception is consent. This is the big one. The warrant requirement protects you from the government, forcing its way into your phone. It does not protect you from yourself. If a police officer asks to see your phone and you hand it over, you just waived your Fourth Amendment protection voluntarily. It doesn't matter that you didn't know you had the right to say no. It doesn't matter that you felt pressured. Legally speaking, consent given is consent given. And here's the uncomfortable truth about that: most people hand over their phones when a cop asks, not because they have something to hide, because they panic, because they think refusing will make them look guilty, because they've never been told clearly and directly that you have the right to say no. You have the right to say no. You can look at a police officer, stay calm, and say, "I don't consent to a search of my phone." That's it. No confrontation, no drama. Just a clear, quiet statement of your rights. The officer may not be happy about it. They may push back verbally, but without your consent, without a warrant, and without a recognized exception, they cannot legally search your phone. The second major exception is called exigent circumstances. This is the legal term for emergencies, situations where getting a warrant isn't practical, because waiting for one would cause immediate harm or allow evidence to be destroyed. If an officer has genuine, articulable reason to believe that delaying a search will result in someone being hurt or critical evidence being wiped, courts have allowed warrantless searches under this exception. But this is supposed to be a narrow exception, not a catch-all. Here's why that matters. Law enforcement has sometimes argued that because phones can be remotely wiped, someone with access to a cloud account could theoretically erase the device from another location. That creates an automatic exigent circumstance, justifying an immediate warrantless search. Courts have largely rejected that argument when remote wiping isn't actually imminent and demonstrated. But it's an argument that gets made, and it's one you should be aware of. The third exception involves crossing an international border, and this one surprises people constantly. When you enter the United States, whether you're a citizen coming home from vacation or a visitor, arriving at an airport, border, agents and customs, and border protection officers operate under a significantly different legal framework. Courts have held that the government's interest in controlling what enters the country at the border justifies a reduced privacy expectation. Border agents can ask to search your phone. They can demand your passcode, and the legal standards governing what they need to do that are much lower than what applies in the interior of the country. People returning from international travel have had their phones searched extensively at airports. This is real. It happens regularly. If you travel internationally and have sensitive information on your phone, professional communications, confidential client data, private personal content, this is something you should be aware of and plan for before you get on that plane. Now, here's something that almost never makes it into these conversations, and I think it's one of the most important practical points in this entire video. Even when police do get a warrant, the warrant has to be specific. The Fourth Amendment requires that search warrants particularly describe what's being searched and what's being looked for. That was designed to prevent general, exploratory rummaging through a person's private life. But when it comes to digital devices, phones, computers, cloud accounts, courts are still working through exactly how specific a digital search warrant needs to be. Some warrants authorize searching all data on a device. That's essentially a general warrant in digital form, and courts are increasingly wrestling with whether that's constitutionally acceptable. Some circuits have pushed back.